Vice President Sara Duterte has nothing but gratitude for her defenders and of course the Supreme Court for striking down her impeachment complaint. But constitutional experts are not as thrilled, citing alleged flaws in the High Tribunal's decision. The big story tonight from Mobile Journal, Aime Atienza.
It's a major legal victory for Vice President Sara Duterte for now. No less than the Supreme Court ruled that the ouster case against the VP cannot go on for lack of due process. Duterte has in the past weeks been out of the country. But in a statement on what she called an unconstitutional fourth impeachment complaint, she thanked her defense team for taking on her case, even when no one else was willing to stand by her. Sara also thanked those who petitioned against the ouster case for having what she calls a conviction to challenge the alleged abuses of the House of Representatives. The vice president even quoted parents, children, and silent supporters who she said offered prayers for justice. In the ruling, the Supreme Court had said Congress can only file another impeachment complaint against VP Duterte on February 6, 2026. Senate President Jesus Cordero has already said the Senate will tackle the High Tribunal's order on August 6. He added the senators will be putting this to a debate and vote on what to do with the impeachment. The lower chamber, for its part, vows to file a motion for reconsideration before the SC. For former Supreme Court Senior Associate Justice Antonio Carpio, the Senate should not take action on the impeachment case for now, as the decision is still not final pending appeal by the House.
If the decision becomes final, of course we have to follow the final ruling of the Supreme Court. It's the final arbiter. No? Whether it's correct or not, that's the final ruling. It's only executory, but not yet final because the House still has a motion for reconsideration. Normally, you act when it's already final. Because there's a chance, because it's not yet final, there's still a chance it could be reversed or changed.
Personally though, Carpio isn't in favor of his former colleague's ruling. In particular, he questioned the part that said the articles of impeachment had no plenary vote before they were transmitted to the Senate. Recall that more than 200 or a third of the House of Representatives signed the impeachment complaint submitted to the upper chamber.
The finding of the Supreme Court in their decision that there was no plenary approval of the fourth complaint is totally wrong because that is not what the records of the House show. There was an actual action, actual vote by the plenary to send the fourth complaint to the Senate. It was even unanimous. Nobody objected.
Carpio also believes the one-year bar rule isn't applicable to the fourth impeachment complaint.
Supreme Court said that the one-year bar rule started to run when the House adjourned. So when the House adjourned, the fourth complaint was already approved by the plenary and it already reached the Senate. So obviously, the one-year bar rule cannot apply to the fourth complaint. The fourth complaint was filed on time.
This was seconded by one of the framers of the 1987 Constitution, Attorney Christian Monsod. In particular, he zeroed in on a portion of the SC ruling, stating that the vice president wasn't given due process in the complaint.
That happens in the hearing in the Senate.
Yes.
So even the basis for the Supreme Court ruling of lack of due process is wrong.
Carpio is suggesting to the Supreme Court now, hold oral arguments before justices decide on the anticipated appeal from the House.
Because it is in the oral argument where you can really see the entire picture. Because
Yes.
the lawyers will have to answer candidly to the court. It's not mandatory, but so that you will have, for you to have a overall appreciation of what happened, you have to call for an oral argument.
Mobile journalist Aime Atienza, we are One News.